Religious law refers to ethical and moral codes taught by religious traditions. Examples include Christian canon law, Islamic sharia, Jewish halakha, and Hindu law. The two most prominent systems, canon law and sharia, differ from other religious laws in that canon law is the codification of Catholic, Anglican and Orthodox law as in civil law, while sharia derives many of its laws from juristic precedent and reasoning by analogy. Established religions and religious institutions. A state religion is a religious body officially endorsed by the state. A theocracy is a form of government in which a god or a deity is recognized as the supreme civil ruler. In both theocracies and some religious jurisdictions, conscientious objectors may cause religious offense. The contrary legal systems are secular states or multicultural societies in which the government does not formally adopt a particular religion, but may either repress all religious activity or enforce tolerance of religious diversity. Baha'i faith. Baha'i laws are laws and ordinances used in the Baha'i faith and are a fundamental part of Baha'i practice. The laws are based on authenticated texts from Baha'u'llah, the founder of the Baha'i faith. Subsequent interpretations from Abdul Baha and Shoghi Effendi and legislation by the Universal House of Justice. Baha'i law is presented as a set of general principles and guidelines, and individuals must apply them as they best seem fit. While some of the social laws are enforced by Baha'i institutions, the emphasis is placed on individuals following the laws based on the conscience, understanding and reasoning, and Baha'is are expected to follow the laws for the love of Baha'u'llah. The laws are seen as the method of the maintenance of order and security in the world. A few examples of laws and basic religious observances of the Kitab-i-Aqdas which are considered obligatory for Baha'is include: recite an obligatory prayer each day. There are 3 such prayers, among which one can be chosen each day. Observe a 19-day fast from sunrise to sunset from March 2nd through March 20th. During this time Baha'is in good health between the ages of 15 and 70 abstain from eating and drinking. Gossip and backbiting are prohibited and viewed as particularly damaging to the individual and their relationships. Buddhism. Patimokkha comprises a collection of precepts for bhikkhus and bhikkhunis. Christianity. Within the framework of Christianity, there are several possible definitions for religious law. One is the Mosaic Law, also called Divine Law or Biblical Law, the most famous example being the Ten Commandments. Another is the instructions of Jesus of Nazareth to his disciples in the Gospel. Another is the Apostolic Decree of Acts chapter 15, which is still observed by the Greek Orthodox Church. Another is canon law in the Catholic, Anglican, and Orthodox Churches. In some Christian denominations, law is often contrasted with grace. The contrast here speaks to attempts to gain salvation by obedience to a code of laws as opposed to seeking salvation through faith in the atonement made by Jesus on the cross. Biblical, Mosaic law. Christian views of the Old Covenant are central to Christian theology, ethics, and practice. The term Old Covenant, also referred to as the Mosaic Covenant, the Law of Moses, Divine Law, Biblical Law or God's Law, refers to the statements or principles of religious law and religious ethics codified in the first 5 books or Pentateuch of the Old Testament. Views of the Old Covenant are expressed in the New Testament, such as Jesus or antitheses of the law, the circumcision controversy in early Christianity, and the incident at Antioch and position of Paul the Apostle and Judaism. Many traditional Christians have the view that only parts are applicable. Many Protestants have the view that none is applicable. Dual covenant theologians have the view that only Noahide laws apply to Gentiles, and a minority have the view that all are still applicable to believers in Jesus and the New Covenant. Canon law. Canon law is the body of laws and regulations made by or adopted by ecclesiastical authority for the government of the Christian organization and its members. It is the internal ecclesiastical law governing the Roman Catholic Church, the Eastern and Oriental Orthodox Churches, and the Anglican Communion of Churches. The way that such church law is legislated, interpreted and at times adjudicated varies widely among these three bodies of churches. In all three traditions, a canon was initially a rule adopted by a church council. These canons formed the foundation of canon law. Canons of the Apostles. The canons of the Apostles, or ecclesiastical canons of the same holy apostles, is a collection of ancient ecclesiastical decrees concerning the government and discipline of the early Christian Church, incorporated with the apostolic constitutions which are part of the ante-Nicene Fathers' Catholic Church. The Catholic Church has the oldest continuously functioning legal system in Western Europe, predating the common and European civil law traditions. What began with rules adopted by the Apostles at the Council of Jerusalem in the 1st century has blossomed into a highly complex and original legal system encapsulating not just norms of the New Testament, but some elements of the Hebrew, Roman, Visigothic, Saxon, and Celtic legal traditions spanning thousands of years of human experience. In the Roman Church, positive ecclesiastical laws, based upon either a mutable divine and natural law, or changeable circumstantial and merely positive law, derive formal authority and promulgation from the Pope, who as supreme pontiff possesses the totality of legislative, executive, and judicial power in his person. The actual subject material of the canons is not just doctrinal or moral in nature, but indeed all-encompassing of the human condition. In the early Church, the first canons were decreed by bishops united in ecumenical councils or local councils. Over time, these canons were supplemented with decretals of the bishops of Rome, which were responses to doubts or problems according to the maxim, Roma locutor est causa finita est. Later, they were gathered together into collections, both unofficial and official. The first truly systematic collection was assembled by the Camaldolese monk Gratian in the 11th century, commonly known as the Decretum Gratiana. Pope Gregory IX is credited with promulgating the first official collection of canons called the Decretalia Gregoriani or Liber Extra. This was followed by the Liber Sextus of Boniface VIII, the Clementines of Clement V, the Extravagantis Joannes 22 and the Extravagantis Communes, all of which followed the same structure as the Liber Extra. All these collections, with the Decretum Gratiana, are together referred to as the Corpus Juris Canonici. After the completion of the Corpus Juris Canonici, subsequent papal legislation was published in periodic volumes called Bullaria. By the 19th century, this body of legislation included some 10,000 norms, many difficult to reconcile with one another due to changes in circumstances and practice. This situation impelled Pope Pius X to order the creation of the first Code of Canon Law, a single volume of clearly stated laws. Under the aegis of the Cardinal Pietro Gaspari, the commission for the codification of canon law was completed under Benedict XV, who promulgated the code, effective in 1918. The work having been begun by Pius X, it was sometimes called the Pio-Benedictine Code, but more often the 1917 Code. In its preparation, centuries of material was examined, scrutinized for authenticity by leading experts, and harmonized as much as possible with opposing canons and even other codes, from the Codex Justinian to the Napoleonic Code. Pope John XXIII initially called for a synod of the Diocese of Rome, an ecumenical council, and an updating to the 1917 Code. After the Second Ecumenical Council of the Vatican closed in 1965, it became apparent that the code would need to be revised in light of the documents and theology of Vatican II. After multiple drafts and many years of discussion, Pope John Paul II promulgated the revised Code of Canon Law in 1983. Containing 1752 canons, it is the law currently binding on the Latin Roman Church. The canon law of the Eastern Catholic Churches, which had developed some different disciplines and practices, underwent its own process of codification, resulting in the Code of Canons of the Eastern Churches promulgated in 1990 by Pope John Paul II. The institutions and practices of canon law paralleled the legal development of much of Europe, and consequently both modern civil law and common law bear the influences of canon law. Edson Luiz Sample, a Brazilian expert in canon law, says that canon law is contained in the genesis of various institutes of civil law, such as the law in continental Europe and Latin American countries. Sample explains that canon law has significant influence in contemporary society. Currently, all Latin Rite Catholic seminary students are expected to take courses in canon law. Some ecclesiastical officials are required to have the doctorate or at least the licentiate in canon law in order to fulfill their functions. Judicial vicars, judges, promoters of justice, defenders of the bond. In addition, vicars general and episcopal vicars are to be doctors or at least licensed in canon law or theology. Uncanonical advocates must either have the doctorate or be truly expert in canon law. Ordinarily, bishops are to have advanced degrees in sacred scripture, theology, or canon law. Saint Raymond de Peñafort, a Spanish Dominican priest, is the patron saint of canonists, due to his important contributions to the science of canon law. Orthodox Churches. The Greek-speaking Orthodox have collected canons and commentaries upon them in a work known as the Pedalin, so named because it is meant to steer the Church. The Orthodox Christian tradition in general treats its canons more as guidelines than as laws, the bishops adjusting them to cultural and other local circumstances. Some Orthodox canon scholars point out that, had the ecumenical councils meant for the canons to be used as laws, they would have called them nomoi, nu omicron mu omicron iota rather than canons, kappa alpha nu omicron nu epsilon sigma, but almost all Orthodox conform to them. The dogmatic decisions of the councils, though, are to be obeyed rather than to be treated as guidelines, since they are essential for the Church's unity. Anglican Communion in the Church of England, the ecclesiastical courts that formerly decided many matters such as disputes relating to marriage, divorce, wills, and defamation, still have jurisdiction of certain church-related matters. Their separate status dates back to the 11th century when the Normans split them off from the mixed secular, religious county and local courts used by the Saxons. In contrast to the other courts of England, the law used in ecclesiastical matters is at least partially a civil law system, not common law, although heavily governed by parliamentary statutes. Since the Reformation, ecclesiastical courts in England have been royal courts. The teaching of canon law at the universities of Oxford and Cambridge was abrogated by Henry VIII. Thereafter, practitioners in the ecclesiastical courts were trained in civil law, receiving a Doctor of Civil Law degree from Oxford, or an LL.D. from Cambridge. Such lawyers were centred at Doctors' Commons, a few streets south of St. Paul's Cathedral in London, where they monopolised probate, matrimonial, and admiralty cases until their jurisdiction was removed to the common law courts in the mid-19th century. Charles I repealed canon law in Scotland in 1638 after uprisings of Covenanters confronting the bishops of Aberdeen following the convention at Mucknall's Castle and other revolts across Scotland earlier that year. Other churches in the Anglican Communion around the world still function under their own private systems of canon law. Presbyterian and Reformed churches. In Presbyterian and Reformed churches, canon law is known as practice and procedure, or church order, and includes the church's laws respecting its government, discipline, legal practice and worship. Lutheranism. The Book of Concord is the historic doctrinal statement of the Lutheran Church, consisting of 10 creedal documents recognized as authoritative in Lutheranism since the 16th century. However, the Book of Concord is a confessional document rather than a book of ecclesiastical rules or discipline, like canon law. Each Lutheran national church establishes its own system of church order and discipline, though these are referred to as canons. The United Methodist Church, the Book of Discipline, contains the laws, rules, policies and guidelines for the United Methodist Church. Hinduism. Hindu law is largely based on the Manu Smriti. It was recognized by the British during their rule of India, but its influence waned after the establishment of the Republic of India, which has a secular legal system. Islam. Sharia, also known as Islamic law, is the moral code and religious law of Islam. Sharia is derived from two primary sources: the precepts set forth in the Quran and the example set by the Islamic prophet Muhammad in the Sunnah. Islamic jurisprudence interprets and extends the application of Sharia to questions not directly addressed in the primary sources by including secondary sources. These secondary sources usually include the consensus of the ulama embodied in ijma, an analogy from the Quran and Sunnah through qiyas. Shia jurists prefer to apply reasoning rather than analogy in order to address difficult questions. Muslims believe Sharia is God's law, but they differ as to what exactly it entails. Modernists, traditionalists and fundamentalists all hold different views of Sharia, as do adherents to different schools of Islamic thought and scholarship. Different countries, societies and cultures have varying interpretations of Sharia as well. Sharia deals with many topics addressed by secular law, including crime, politics and economics, as well as personal matters such as sexual intercourse, hygiene, diet, prayer, and fasting. Where it has official status, Sharia is applied by Islamic judges, or Qadis. The imam has varying responsibilities depending on the interpretation of Sharia, while the term is commonly used to refer to the leader of communal prayers. The imam may also be a scholar, religious leader, or political leader. The reintroduction of Sharia is a long-standing goal for Islamist movements in Muslim countries. Some Muslim minorities in Asia have maintained institutional recognition of Sharia to adjudicate their personal and community affairs. In Western countries, where Muslim immigration is more recent, Muslim minorities have introduced Sharia family law, for use in their own disputes, with varying degrees of success, e.g., Britain's Muslim Arbitration Tribunal. Attempts by Muslims to impose Sharia on non-Muslims in countries with large Muslim populations have been accompanied by controversy, violence, and even warfare. Judaism. Halakha is the collective body of rabbinic Jewish religious laws derived from the written and oral Torah, including the Mishnah, the Halakhic Midrash, the Talmud, and its commentaries. After the destruction of the Second Temple by the Romans in the year 70 during the First Jewish-Roman War, the oral law was developed through intensive and expansive interpretations of the written Torah. The halakha has developed gradually through a variety of legal and quasi-legal mechanisms, including judicial decisions, legislative enactments, and customary law. The literature of questions to rabbis, and their considered answers, are referred to as responsa. Over time, as practices developed, codes of Jewish law were written based on Talmudist literature and responsa. The most influential code, the Shulchan Aruch, guides the religious practice of most Orthodox and some conservative Jews. According to rabbinic tradition, there are 613 mitzvot in the written Torah. The mitzvot in the Torah pertain to nearly every aspect of human life. Some of these laws are directed only to men or to women, some only to the ancient priestly groups, members of the tribe of Levi, some only to farmers within the land of Israel. Some laws are only applicable when there is a temple in Jerusalem. Wicca. The Wiccan Rede is a statement that provides the key moral system in the neo-pagan religion of Wicca and certain other related witchcraft-based faiths. A common form of the Rede is, "and it harm none, do what ye will."